Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 35 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering cases decided between February 17th, 2021 and February 23rd, 2021. The courts decided a lot of cases this week, 5 of which will be addressed in today's podcast. The defendant in the case of Commonwealth v. Young pled guilty to third-degree murder and conspiracy in Pennsylvania in 1976. He was sentenced to 1 to 20 years and was paroled after approximately 2.5 years. Upon his release, he absconded to Kentucky. In 1981, the defendant was convicted of rape and sodomy in Kentucky. His conviction there carried a lifetime reporting requirement under Kentucky law. After serving his full sentence in Kentucky, the defendant was transferred to Pennsylvania to serve the balance of his conviction for the murder case. Upon his release in 2018, he was informed that he was subject to Pennsylvania's sex offender registration requirements as a result of his Kentucky convictions. He filed a PCRA petition in the Pennsylvania case claiming that he cannot be subject to Pennsylvania's registration requirements as that law was not in effect when he was convicted in Kentucky in 1981, and it therefore violates ex post facto principles. As a preliminary matter, the court must determine whether it even has jurisdiction to hear the case. Here, the appeal arises from the docket number associated with the Pennsylvania murder and conspiracy convictions. Nevertheless, in this appeal, the defendant seeks to challenge the sex offender registration requirements that arise from a foreign judgment of sentence in Kentucky. As these sex offender registration requirements are entirely separate from his murder or conspiracy convictions or sentences, the Superior Court lacks jurisdiction to review them in this appeal. The court notes that while this is not the proper avenue for relief, to the extent that the defendant might have a valid ex post facto claim, he can file a petition for review in the Commonwealth Court. The case of Commonwealth v. Felder is a unique case, as both the defendant and the Commonwealth agree that there is newly discovered evidence, which is grounds for a new trial. However, the Superior Court found that because the trial court acted within its discretion when it denied the new trial request, the Superior Court affirms the judgment of the trial court. The defendant was convicted at trial of a number of firearms-related charges. Following his conviction, it came to light that the officer who testified had been found incredible in 2 previous cases. This information was not disclosed to the defense. At the time, the district attorney who was trying the case was also unaware. He promptly turned over the information as soon as he became aware. The defendant filed a request for a new trial, and the Commonwealth joined in that request. A criminal defendant seeking to assail a guilty verdict and retry a case with after-discovered evidence must clear 4 hurdles. He must convince the trial court that the evidence, 1, could not have been obtained prior to the conclusion of the trial by the exercise of reasonable diligence, 2, is not merely corroborative or cumulative, 3, will not be used solely to impeach the credibility of a witness, and 4, would likely result in a different verdict if a new trial were granted. The test is conjunctive, meaning that the defendant must show by a preponderance of the evidence that each of these factors has been met in order for a new trial to be warranted. In analysis of this case, the Superior Court notes that both the defendant and the Commonwealth improperly attempt to litigate the after-discovered evidence issue on appeal de novo. The Superior Court, however, cannot simply substitute its judgment for that of the trial court. The Superior Court has no authority to second-guess a ruling committed to the sound discretion of the trial court. After-discovered evidence is peculiarly a question to the trial court's discretion because that court is uniquely positioned and qualified to appraise the reliability of the original trial and the proposed evidence's impact upon it. The scope of review is again an abuse of discretion standard. The court cannot review errors of a party even when, as here, the government confesses constitutional violations. The court can only review whether the court abused its discretion in denying a motion for a new trial. In this case, evaluation of the 3rd prong is dispositive of the matter. The trial court found that the after-discovered evidence would only be used to impeach the credibility of the officer. Counsel for the defendant admitted as much. Because the motion does not satisfy the 3rd prong, the trial court made a sound and well-reasoned judgment and did not abuse its discretion. The judgment of the trial court is affirmed. In Commonwealth v. Shaw, the defendant was convicted of possession of a controlled substance and possession of drug paraphernalia. The defendant appeals on the ground that the trial court erred in denying his motion to suppress. The defendant was stopped for failure to have properly illuminated license plates. Upon contact, the officer stated that he could smell the odor of marijuana. The officer told the defendant that the odor of marijuana is probable cause to search a vehicle. The defendant refused to consent to a search. The officer searched the vehicle anyway and discovered marijuana and drug paraphernalia. No contraband was found on the defendant's person. While this appeal was pending, the Pennsylvania Supreme Court decided the case of Commonwealth v. Alexander, which overruled previous case law regarding probable cause in vehicle searches. The Supreme Court held that warrantless vehicle searches require both probable cause and exigent circumstances. Also, while this appeal was pending, the Superior Court decided the case of Commonwealth v. Barr, which held that the odor of marijuana alone is not sufficient to establish probable cause to search a vehicle. As a result of those two opinions, the defendant's judgment of sentence is reversed and the case is remanded for further proceedings consistent with the decisions in Alexander and Barr. Commonwealth v. Carter came before the Superior Court after the defendant was convicted of several sex crimes on 9 different criminal dockets. Following his conviction, he requested bail pending sentencing and appeal. His request was denied. He then filed a notice of appeal. Pursuant to the current rules of appellate procedure, which went into effect in August of 2020, requires that in this situation the defendant should have filed a petition for specialized review. Previously, these orders were considered under Chapter 15, which had specific provision indicating that if an appeal is taken improvidently from an order of court, the papers related to that appeal shall be regarded and acted upon as a petition for review. However, in August 2020, with the reorganization of the rules of appellate procedure, a new Chapter 16 was created to handle these petitions for specialized review, which includes review of orders regarding bail. There is no analogous provision directing the court to treat an improvident appeal as a petition for specialized review rather than to quash it as interlocutory. If the Supreme Court had intended the new framework to continue the previous practice, presumably it would have included the proper provisions in the new rule. The court must assume that such an omission manifests the Supreme Court's intent to disallow the regarding of an improperly filed notice of appeal as a petition for specialized review. Here, as this was an improper filing, the court must quash the appeal as they lack proper jurisdiction to address the merits of the case. In Commonwealth v. Hudson Greenlee, the defendant was charged with child abuse. During the trial, the child victim was permitted to testify by contemporaneous alternative method pursuant to the tender years exception. This decision came after a hearing on the issue where the child witness was observed and questioned by the judge outside the courtroom. Following a conviction at trial, the defendant appealed, claiming that it was error to allow the child victim to testify by contemporaneous alternative method. When reviewing the admissibility of evidence, admissibility is at the discretion of the trial court and will constitute reversible error only by a showing of an abuse of discretion resulting in prejudice. The tender years exception allows a witness to testify by contemporaneous alternative means when a determination is made that the child victim will suffer serious emotional distress that would impair the child victim's ability to communicate. In this case, the court observed through the process of questioning numerous indicia that she would suffer as a result of being in the presence of the defendant. The order of the court clearly indicated that in addition to considering the testimony of the child victim's adoptive mother, the court had the opportunity to both observe the child's demeanor and assess her state of mind in the scope of the entire circumstances surrounding the proceeding prior to rendering its decision. The Superior Court discerns no abuse of discretion. Further, the defendant failed to establish that the decision to allow the child victim to testify via closed-circuit television either harmed or prejudiced her at trial. For these reasons, no error was found on behalf of the trial court judge, and therefore the judgment of sentence is affirmed. Thank you again for joining us. Please find the links to the full text of each case, including those discussed today, as well as those not discussed today, in the episode's case notes. Have an awesome week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.